It is lovely to see you here. In this series, we invite experts from around the world to talk about comparative law as a methodology. The event is a collaboration between the Graduate Colloquium from Indiana University-Maurer School of Law and Law and Science. On behalf of Eka Putra, as the coordinator of the Graduate Colloquium, I'd like to introduce the mission of the Colloquium. The Graduate Colloquium is a biweekly online meeting for graduate students at Maurer School of Law to discuss common academic concerns and research interests. Law Science is an academic initiative created by Faris Al-Malki and me. We aim to promote the study of law by bringing diverse methodological perspectives on the different issues of law. If you're interested in more law science events, please join our email list by clicking the link we have shared in the chat box. Today, we are honored to invite Professor Shitong Qiao to talk about Chinese comparative law. Dr. Shitong Qiao is an associate professor at the University of Hong Kong, Faculty of Law. He served as a Law and Public Affairs Fellow at Princeton University, the King Young, Dr. Young, and Gina Park Young Visiting Assistant Professor at Duke University, and the inaugural Jerome Cohen Visiting Professor of Law at New York University. Dr. Qiao is an expert on property and urban law with a focus on comparative law and China. He has published a number of journal articles and book chapters. His research has been cited by property and urban law theorists, scholars of China studies, and Chinese policymakers and Supreme People's Court judges, and has been covered by leading Chinese and English media. Dr. Qiao has served as an expert witness on Chinese property regime in China, Canada, and the United States. Dr. Qiao received his Bachelor's of Laws degree from Wuhan University, Master of Philosophy degree from Beijing University, and LLM SJD degree from Yale Law School. Without further ado, let's welcome Professor Qiao.
Thank you, Simon, for the invitation and also for, as I have said, many emails we have exchanged. So it's a lot of work, and I'm very honored and happy to be here. So let me just share my slides first. Say. So I see a couple familiar names here, so that's great. And even if the topic of the topic, sorry, just one moment, is really about comparative Chinese law, so which is narrow. But I want to assure people who don't study Chinese law here, that's most of you, is going to be fine, because a major theme of this talk is basically to share with you my very preliminary understandings of how to do comparative law in American legal academic. So, so it's not only about Chinese law. Okay, so that's for most of the people here. Anyway, so it's not really a conventional topic for me. Normally, in the past years, when I do presentations in different parts of the world, it's really about like a specific a topic, like a paper I'm working on or the book I'm working on. So this is more about methods, right? As I understand, this series is also part of the Indiana graduate colloquium. So, so anyway, let's get started. Firstly, I just want to share with you my view of the landscape of comparative law, right? One is the old or the conventional paradigm, which is civil law versus common law. Civil law here, as I understand it, mostly is continental civil law, right? It's more like continental European civil law. So that's a conventional paradigm. It's the old paradigm but it's still a living paradigm. So I'm not saying that it's not important. But for today, I want to focus on the country region specific studies. As I understand, that's kind of a thing many graduate students from other countries in the US law schools, like what they are doing, right? As that's what I saw when I was at Yale doing my GSD studies, right? So for this category, it's kind of different from the previous one, civil law versus common law, right? So think about the landscape. We had Soviet law, That's many years ago. That's basically during the Cold War, right? And for Soviet law, there were actually tons of literature. But at the center of it, I think is about law and politics and law and state, right? And more recently, we have studies of Islamic law. For example, at Harvard Law School, UCLA currently actually have professors who specialize in Islamic law. And for this area, is more focused on like law and religion, maybe also law and national security. Actually, following Soviet law at about the 1980s, right? What I'm familiar about, right? In US law schools, we also have the rise of Japanese law. So for Japanese law, I'm going to review a little bit further. The focus is really about like at least two focus. One is law and development, because Japanese was number two. And just like China today, everybody thought Japanese would be number one in the world. So there were like lots of passion and interest about Japanese law from the perspective of law and development. But there is also at least the other perspective of studying Japanese law in American law schools. That's law and culture, because Japan is well known and also is famous for its distinct culture, right? It's a non-Western culture with its own characteristics. So how to understand the relationship between law and culture in such a society. That's what Japanese law is about. Since our host is Simon, as I understand, you're probably from Asia, right? And probably a few of students here are also from Asia. So I'll just say a little bit. It's really my own perspective. I don't think this landscape is going to be comprehensive. So it's one view of the landscape of comparative law in American law schools, right? Also Asian law. So that's also about like 1970s, 1980s, also 1990s. There were, I mean, until today, there was also some interest in Asian law, right? Mostly like the four little dragons, Taiwan, Hong Kong, South Korea, and Singapore, right? So these Asian jurisdictions had quite a successful economic development. So what's exactly the relationship between law and development in these jurisdictions? That was a question quite popular in 1990s. Right? Actually, recently on the horizon, we saw the rise of Vietnamese law, actually, just in the past decade, because of the success of the Vietnamese economic development. So for this category of Asian law, I put into this category basically the four little dragons, Vietnam. I think the focus is about law and development. And for Singapore, there's also this flavor of comparative constitutional law, right? So-called authoritarian constitutions, right? So it's basically to understand, the relationship about constitutionalism, authoritarianism in Singapore, right? The interactions between state and society. But overall, for this category is law and development. Then again, Chinese law is an area I'm familiar with, right? And also what I'm doing. A permanent question, basically, since I was a graduate student at Yale Law School, is really about how to understand Chinese law, right? From an external perspective, right? And even for our graduate students today, I believe, right, every day we wake up with a question, like, what's going to be a meaningful research? How could I make a contribution to the field, right? And how to define this field, right? That's something I have been thinking about, and I'm very honored here to share with you my thoughts. But again, I have to warn you, I don't think really I have an answer. It's just my personal perspectives. I do look forward to our Q&A. Maybe you can give me some clue, right? So anyway, as a preliminary observation, I think Chinese law seems to be complicated. It has really different dimensions, right? One dimension is actually culture and history, because just like Japan, right, to a certain degree. But a second dimension is about development. So China has now is like 4 decades rapid, I wouldn't call it unprecedented, but really, really amazing economic development. And to a certain degree, without the typical Western legal systems. Then that's like the bigger puzzle there, right? Why China has had such amazing economic development without the typical Western style legal systems, right? Like 20 years ago, people would simply say, oh, why China has had 2 decades amazing economic development without rule of law. Now I think actually exactly because of this puzzle, because China's distinct legal practice, we have kind of reframed that question. I think that, as I will say later, actually poses a fundamental challenge to our understanding of the nature of law. So what's exactly law, right? In the Chinese context, but also universally. Right? And the last dimension, probably not the last, but the third dimension I can think of about Chinese law, it's kind of like similar to Soviet law, right? It's a party state, right? And so the government plays a very proactive and interventionist role in economy and society. So law and politics, or law and state, is another dimension to understand the Chinese law. So that's the landscape of comparative law, probably a partial one in my own view. So I would like to focus on the country and the region specific studies. Because, right, just to talk a little bit more, again, my confusion about studying Chinese law. I think it's probably also applicable to students from other jurisdictions, Africa, South America, Europe, right, Asia. Right? It's like when you focus on a specific country, right? If this country is in rapid development, for good or bad, there are just so many topics to work on. Your American law advisors, right? Your people who are on your committee, they may do criminal law, constitutional law, internet law, 3 or 4 areas. That's okay. I mean, our American law professors are very versatile, right? They do lots of things. Nevertheless, they only do a few areas of American law, right? But when you do comparative law, you say, I do Chinese law or I do Japanese law. Wow, that's the entire country. And every area of that country's law, you are supposed to cover. And for China, the thing is that it's so exciting. When I started at Yale, that's like more than 10 years ago, right? Whenever I read an article on The Economist about China, I felt like very excited. Oh, this is a potential topic. But now The Economist has a special section on China, right? Every issue. So every day we read news about China from New York Times or Wall Street Journal, right? Criminal justice, human rights, corruption, right? Corporate governance, antitrust, right? Legal history even, or international law, like one belt, one road. And law and society, Chinese courts, Chinese lawyers, workers, NGOs, internet, and data governance, right? And also US-China trade war. So it's everywhere, right? Sometimes I do, although I'm a very probably narrowly focused person, I do feel like being overwhelmed, right? What to do with Chinese law, or what to do with comparative law, right? This country-specific comparative law is just overwhelming, right? So the answer is probably just too much to do, right? So when I was preparing for this lecture, I really thought about Confucius because I was confused, right? So I think he has a saying, right? Learning without thinking is labor lost. So for me is that, well, there are many things to cover in a specific country. There are many things to cover in the entire world, right? Whatever jurisdictions you are covering, one jurisdiction or multiple jurisdictions. But I think probably, I don't know for sure, the most important thing is not to just master the details of this specific area of law, right? You should, right? We should understand the law as it is in this country in the specific social, cultural, and political context. That's the basic. But one step further, the lesson from Confucius is that we have to convert such knowledge, such details into thinking, right? To think about, okay, what does this specific area, data governance, cyber law, what's like the fundamental nature of cyber law, for example, or what's the fundamental nature of Chinese law, or what's the fundamental nature of Japanese law, right? And even further, what does it tell us about law itself, right? Or law in society? I think it's just, we have to think a bit further to, I will give you, again, just my own biased view. Probably one criteria is that for anybody who does not work on cyber law, or for anybody who does not work on Chinese law, who does not work on Japanese law, what can you tell him or her, right? To make it more universal. Because if you have nothing to tell him or her, then that means your contribution is probably going to be limited, right? So that's the confusion, and that's the lesson, right? I'm trying to draw from Confucius, probably the greatest Chinese thinker in history, right? So in the following minutes, I'm just going to share with you basically my exploration, right? When I thought about the rise and fall of country-specific legal studies in American law schools, I'm thinking about that could actually tell us something about the future of comparative law in American law schools, whether it's Chinese law, Japanese law, or any other law, right? Eventually, as you will see, for example, Soviet law is going to die out, right? So Soviet law is a nice example. It has been so many years. And back then, there were professors at Harvard, at Yale, and at Columbia who were studying Soviet law. But many decades later, what has been left? That's a question I'm asking, because I always had this anxiety. Whatever I'm doing today about China, it's going to be forgotten tomorrow. Maybe not tomorrow, but next year, because there are going to be new topics or new headlines on New York Times, right? It's not that I don't want to be forgotten. It's that if that's the case, that means what I'm doing is not that meaningful. So maybe we can draw some lesson from history. So that's what I want to explore together with you. So I would like to just focus on, just for the interest of time, I just want to focus on two country-specific studies, Soviet law and Japanese law, for me, because they are closer to Chinese law. Okay, let me just take a look at time to make sure that yeah, okay, that's fine. Firstly, this professor here, Professor Harold Berman, right? I'm sure this name should sound at least familiar, at least to some of you. Right? And why do we remember him, or why is the name familiar to us? I'm sure some of you know, right? Because of this book, Law and Revolution, which had been translated to many languages in the world, and it explores, right? So one of the main things in the interactions between the Western belief in legal evolution and the periodic outbreaks of apocalyptic revolutionary upheavals. So it's about law and revolution, right? And in this book, Berman challenges conventional nationalist approaches to legal history, which have neglected the common foundations of all Western legal systems. He also questions conventional social theory, which had paid insufficient attention to the origin of modern Western legal systems, and has therefore misjudged the nature of the crisis of the legal tradition in the 21st century. So this book, since its publication actually quite a few decades ago, has become a standing point, right, of departure for work in the field of Western legal history. So that's why we remember him, remember Professor Harold Berman, who was teaching at Harvard for many decades, and then at Emory Law School. But you might not know that Professor Harold Berman actually was the leading figure of Soviet law in American law schools. How many of you know that? Maybe you know. So anyway, so he has this book and actually quite a few other books about Soviet law, about the USSR, like Justice in the USSR. You can take a look at the chapters. It's like an encyclopedia of Soviet law. And I can assure you, it takes a lot of time, lots of visits back then to Soviet Union to really to have the deep knowledge about Soviet law. And it's extremely valuable. I'm sure it was extremely valuable and is still valuable today. But we remember today mostly law and revolution, not justice in the USSR, right? So that gives me probably two lessons. First one is going back to Confucius, right? Knowledge without thinking is the waste of labor. I wouldn't call the book a waste of labor, just to see that eventually for your contribution in the field, you have to go like one step further. So that's one lesson from Professor Harold Berman. The second lesson actually is to take a closer look at this book. There is actually a fundamental connection between this book, The Justice in the USSR, which was published in 1963, and the first book, Law and Revolution, which was published in 1985. So I would say that Professor Berman's study of USSR law probably has also built a foundation, right, for him to think about more generally law and revolution. Actually, if you see the chapters here, there is, I think, a chapter here, like chapter 6, is about Western legal tradition. And as I have said, for the contribution of law and revolution, is to understand the relationship between the Western belief in legal evolution and the periodic outbreaks of revolutionary upheavals, right? So one is specific, the other is general, but they are, we should read them together to understand like the career path and also the path of thinking of Professor Harold Berman. So that's the first legend, right? And the second legend is not a really Soviet law, but is from that area, right? But I think it's also under the influence of Soviet law. It's Professor Miriam Damaska at Yale Law School, and he is a living legend because he's still there, right? And for his book, I mean, he has many books, and he's a living legend. Just since it's kind of informal session, right? For many reasons, but firstly, he does not have any U.S. law degree. He basically in 1971. He left his native land, Croatia, right, and accepted a tenured position at Penn Law, and later joined Yale Law School. So what's like his most important contribution? I'm sure you know if you study courts, study comparative constitutional law. His book, The Thesis of Justice and State Authority, is still very much actually frequently read, cited, and taught in seminars about the courts, about comparative constitutional law. And if you see the question he's asking, basically the first paragraph of his entire book, he asks a very simple, but a very universal and fundamentally important question. That's like, does the legal process require an interaction of three independent sides, right? A claimant, a respondent, and a decision maker, or just between an individual and a state official, right? It's a universal question. And with this question, he provides us with a comprehensive and right, a theory of different kinds of legal process in the world, right? In some countries, such as Soviet Union, right, is more like the two-party game, right, between a state and an individual. but in the common law jurisdictions such as the US, it's more like a three-side game, right? The claimant, respondent, and the decision maker. So Professor Harold Berman actually recommended this book by saying that this book constructs a conceptual framework of the legal process, right? And based on the link between politics and justice. And it enables disparate procedural features to emerge as fascinating, recognizable patterns, right? So that's Professor Damaska, right? So I think the lesson from Soviet law, from Professor Berman and Professor Damaska, is that both we can say are inspired by their experience and their knowledge and their study and their research about Soviet law. But eventually, the question they are asking or the fundamental contribution they make to legal theory is universal. Anybody who has no interest at all about Soviet law, they would be interested in their books and research, right? So that's Soviet law. Now we are coming closer to where I am right now, Hong Kong. So we're moving from Soviet Union or Russia to Japan. Actually, even today, there are a group of scholars in leading law schools in the US who has studied Japanese law, right? Or who is still studying Japanese law. This list is not going to be comprehensive. So I'm just going to give you 3 examples that I'm familiar with. The first one, right? Professor John Haley at Washington at St. Louis and Emeritus, right? So his book, that's like one of the first about Japanese law, the spirit of Japanese law. So it's so this one is very Japanese law, meaning that it does not really like Professor Berman or Professor Damaska has done, right? Really contributing. At least it does not focus on like fundamental legal theory, but its contribution is based on in-depth investigation of Japanese law, and most importantly, right, he really reveals, at least in his view, the fundamental nature of Japanese law, which is the communitarian orientation. That's why he calls it the spirit of Japanese law. That helps us really understand Japan, right? If there's only one thing about Japanese law you want to know, right? Most of us here, we are not interested in the details of Japanese law if we don't live in Japan or do business with Japan. But we got to know the communitarian orientation, and he even further discusses how this communitarian orientation actually impacts the Japanese judiciary and society. Right? So that's one thing we can do. It's like Chinese law, Asian law, European law. Like what's the fundamental spirit? Right? That's also a very important contribution. Right? And to think about this is not only a contribution about Japanese law, because I think for for Americans or just for any person who wants to understand his own culture, to study other cultures, that's also a way to deepen your understanding of your own culture, right? This communitarian orientation is very much different from the individualistic culture in the US. So that makes it also a contribution to the general understanding of law and society, right? So that's the first book of Japanese law. And the second book of Japanese law is Professor Frank Upham at NYU Law School, this Law and Social Change in Post-War Japan. So this book is really just showing us that, I mean, back then, put it in context, right? People would think that Japanese, is law does not play like a significant role in Japanese society, not as in the US. But Professor Upham actually, this was the first book, demonstrated that that was not the case. Actually, law played a very important role in Japanese society, not only for ordinary people, but also for politicians, right? But for me, a person who is interested in law and development, this also contributes to the general understanding of law and development, right? And also his discussing of the legal system is not only about judicial decisions, it's also the informal norms of the legal system. So that makes this book quite a path-breaking back then. And now it's like the major paradigm, right, to study judiciary and also law and social change in countries around the world. And the last one is Professor Mark West at Michigan Law School, right? His book about law in everyday Japan. You can say it's, I mean, I highly recommend this book because it's just interesting to read, right? Fascinating explanations of what's going on in Japan in everyday life in Japan. But you can see that just from the website, right? The contribution is that, okay, for John Haley, for Frank Upham, you guys all focus on courts, but we know that lawsuits are rare events in most people's lives, even in the US, right? So he basically shifted the focus to, beyond the courts, to the everyday life, such as, mafia or sex workers or disputes between neighbors, right? So that makes his book innovative. But eventually, if I have to summarize what's going on in the field of Japanese law, it's really about two questions. Firstly, whether law matters in Japanese society. And many of the books eventually conclude that, actually different from the common assumption, law matters a lot in Japanese society. But second question is, how does law matter in Japanese society, right? That's a bit more complicated. So that's also basically my approach to comparative law. Probably, I mean, to Chinese law because I'm mostly familiar with this jurisdiction. But I think that's a fundamental question for people who are doing comparative law or focusing on specific countries. There are two questions to answer. I mean, there are more questions to answer, but I think the starting point is, does law matter in this jurisdiction? And the second one, how does it matter? And eventually, as I have said, it's going to further our understanding of the nature of law and also law's function in society. Because in a Western society, particularly in American society, I think people, even legal scholars, are very familiar with what I would call the enforcement-centric approach to law, right? Laws, they are being made, right? And different kinds of influence of interest groups. But once it's made, the law enforcement officials and also the courts, they're supposed to enforce the law. Simple and easy. And us, Soviet law, Japanese law, or Islamic law scholars have actually discovered that's not the case. Law in other jurisdictions, in other cultures, are just more complicated. Even in those countries originally we thought would be against the law or would be lawless, it turns out that there are actually lots of laws in such places, right? In authoritarian regimes, right? So then we really have to have a new idea, maybe a broader concept of the nature of law or the definition of law. So for me, I just want to share with you my experience, not necessarily successful, but it's just how I have taken on the issue. So in my first book, I really focus on the first question, like, does law matter in China? So to answer that question, I actually focus on an area there seems to be no law, right? So it's a lawless place. The specific question I have asked is whether there is a real estate market without legal titles. So for me, this question is meaningful in two senses. First one, it goes back to our point, like, does law matter in China, right? Or does law matter in any area? But second one, it's also a question about law and development. because the conventional wisdom, even until today, after my book, right, is that wow, for economic development to take off, you need well-functioning legal systems, property rights, contract rights, and even constitutional law. In retrospect, at least from my perspective, that's simply a lie, or simply just too naive. And for very simple reasons, it ignores the cost of legal systems. Because for developing country, how could you have such a costly legal system in place at the beginning of reform, right? There are many other priorities: water, electricity, roads, right? Basic security. How could you, law is more like a luxury good. How could you expect to have at least the Western style, well-functioning legal system to be there at the beginning of development, right? It's just hard to imagine if you have this flavor of reality. But that's the background. But come back to this specific literature I'm focusing on. So before my book, the answer to the question of whether there could be an impersonal market without legal titles, the answer is no. And they are discussing about informal settlements, right? Slums are basically saying that these places, such as the picture on the left, I think is informal settlement in Peru. The picture on the right is Johannesburg in South Africa. Is that life in such places are poor, nasty, brutish, and short. Adults have to stay in their house, at least one adult must be there 24 hours a day to protect their possession, right? But what I found in Shenzhen, across the border from Hong Kong, 10 years ago, not many people knew about this place, at least for people outside of China. It's like the urban villages, the buildings, they don't have legal titles. But life there, right? Is basically these shorter buildings, which were built by the farmers, against the legal prohibition and had no legal titles at all. But what I found is that there was actually a vibrant market, millions of impersonal transactions about such real estate, right? And life there in such urban villages, I took the pictures, are pretty happy. This is me, right? Are pretty happy there. Food, everything. Maybe a lot of the high-end consumption, but it's pretty good, right? Particularly providing an affordable place to 8 million migrant workers in this place. And the Shenzhen itself is an ideal site for studying law and development. Why? Because 40 years ago, it was an agricultural county of only 300,000 people. And now it's called China's Silicon Valley, with 15 million to 20 million people, right? High tech, everything, so glamorous. But you know what? Back to early 1980s, there was not much law, right? Then that's, I think, at least a counterexample to the conventional literature on law and development. So I go further from there, right, to say it's not only about happy life, about food, because these are informal buildings, what I call small property, or what's called small property by local people, they also served as the basis of industrial development. We know Huawei, right? We know Tencent. Tencent at the very beginning, their office were in such small properties. That was early 1990s when the founders were just graduated from college. And also they served as commercial centers and even police stations and schools, right? And with such discovery, how could you say that for economic development to take off, you need a well-functioning property law system and legal titles? That's clearly not the case. So eventually, just for interest of time, I won't dwell on it. So you can find a book online, right? I eventually developed this theory, what I call the co-evolution of law and social norms, right? So my advisor at Yale, Bob Erickson, his book is called Order Without Law, but it does not have this development perspective. And what's more important, his understanding of law and social norms, which dominates the discussions in the after his book the publication, was about the choice of law and social norms. So it's a static model. It's a static model, right? But my model is a dynamic one, right? It's really about like in a rapidly changing society and economy. It's not really about the choice between law and social norms. It's really about how they co-evolve with each other, right? Like one change in one area could lead to a change in another. How does that happen? How does that happen? So that's like my first book, to start from the question of whether law matters in China, but going further to have this theory about the co-evolution of law and social norms. So, well, I thought the book would be outdated just after its publication, but today after rereading it, I thought it was still good, and the theory still, I think, is quite valuable for us to understanding the relationship between law and society. Right? So that's the first book. And the second thing I'm working on, so I'm becoming, I'm changing from an outlaw to a law person. So the second book, which is under contract with Cambridge, I'm going to study a phenomenon, so going from urban villages to the middle class neighborhood. And also I'm going from lawless to lawful. So what I'm studying is that, Chinese property law and also the civil code has a very simple article. Basically says homeowners in China, right? The legal ones, which have, spent a lot of their income, their wealth purchasing an apartment, right? Basically, is this neighborhood. I can show you, right? This is actually a neighborhood in Shanghai. In translation could be called like a city of riverside, but it's not a city. It's a neighborhood. You can see all these buildings of the same style. It's 12,000 households. Okay. Recently, I think like 2 weeks ago, just had a re-election of their homeowners associations. Okay, 12,000 people in the heart of Shanghai, a democratic election, right? So that's what makes it interesting. I call it authoritarian commons, or in other words, how could you have community self-governance or homeowner self-governance in the heart of mega cities of the most powerful authoritarian state in the world, right? Because authoritarianism poses a tripartite challenge to law and development, right? Firstly, property rights, right? The government could encroach upon property rights, so property rights might be insecure, and also rule of law, because we thought authoritarian regimes, they are not necessarily rule-based, right? Because it's kind of more discretion. And lastly, is the centralized nature of authoritarianism could also go against, for example, what this picture shows, the bottom-up grassroots democracy, right? So the paradox, which I say in this neighborhood, and actually in 66 neighborhoods in Beijing, Shanghai, and Shenzhen I have visited, is that firstly, you have law in the book, right? In property law, civil code, which actually sanctions homeowner self-governance. So it's a legal right to do it, right? But that does not mean, so having a legal right does not mean that people are going to be able to establish the homeowners associations, a kind of democratic form of governance in their neighborhoods. Actually, my fieldwork, like almost 1.5 years, found that in Beijing, only 12% of the residential neighborhoods have such associations. And Shenzhen is 41%, but in Shanghai is 94%. So like the first part of my paper is basically trying to understand the difference across these cities. So what makes the difference, right? But the first question is really, what's exactly the nature of law if law is not going to be enforced, right? And to answer that question, we have to ask the question of why is law enforced in some cities, such as Shanghai, but not in Beijing, and not very well in Shenzhen. So what's exactly the reason, right? Eventually, just to for interest of time, I conclude that the nature of law, we have to understand the nature of law from a coordination perspective, from the perspective of the bargaining between the state and its citizens. So to put it in an oversimplified version, I write in my paper that law serves as a prospectus, right? I mean, some legal philosophers said law is planning, but I use the word prospectus. It's not even planning. It's like one step of bargaining. I'll say the state makes this move to say how the citizens is going to respond later, and then next step. So law is these steps in a continuous bargaining process, right? Eventually, this two-party game instead of the neutral third-party institution, right? So if we want to understand non-Western legal institutions, particularly like in authoritarian regimes or in regimes which seem to not have much law, we just have to take this broader perspective of understanding law as bargaining, right? So that's work in progress. The last point I want to make, it's something. It's to say, even for country-specific studies, I'm sure many of you are doing, we have to, well, at a certain stage, we should make an effort to make them comparative. And of course, there is always a trade-off between depth and width. So I'm not doing particularly well because my study of China is very much context specific. For each project, it takes actually many years, because for field work, it takes at least 1 year. So I just have not been able to do that in-depth field work in other countries. So my comparative work is not as successful as, say, for example, like two scholars who are quite successful. One is Professor Ben Nok-song, who is actually a Hong Kong PhD graduate, but was recently appointed as at Oxford Law School, right? But his focus is actually socialist law, and there are not many, but he provides a comprehensive review of all the socialist constitutions in the world. So that's quite a contribution. And last one is this comparative constitutional law about constitutional amendments, which is quite successful. But anyway, last word. We have been thinking about many things every day. That's just a destiny of GSD graduate students or an academic. Eventually, I would say, whatever it is, whatever your choice is, the method is, eventually I do think is what drives you is your interest and passion. I think that's probably at a fundamental level higher than what we have talked about. So anyway, thanks again for the invitation, and good luck for our graduate students here. Thank you.
Thank you so much, Professor Shitong Qiao. That was a very insightful presentation, and I learned so much just listening to you talk about those. So we have entered the Q&A session. If you have any questions, you may raise your hand. And at the meantime, I do have some questions. I have 2 questions. So I think there is a difference between comparing a legal concept and a legal system, right? And of course, your major is property law. Can you talk a little bit more about that difference when you're comparing like 2 legal concepts in comparison to hold like the property regime in the United States and China? And also, when you're doing that comparative work, some people say that comparative research is also the art of translation. How do you choose the appropriate translation to effectively convey the meaning, and it also kind of reflects the cultural background? How do you do that translated work?
Oh, very nice. I think they touched upon actually a main theme of this talk. So I don't think it's about translation. I think it's I understand the challenge, right? Whenever you try to do comparative research, there are challenges because a same concept could be very different implications in different contexts. Even again, the concept of law could be totally different. For example, when I was an expert in American courts, So there were like lots of questions about the fundamental nature of Chinese law, whether it was enforceable, etc. But going back to your question about the different concepts of law, that's frank speaking, that's not what I usually do. Normally, I just wouldn't be I wouldn't be attached too much to a specific legal concept. For me, I guess one message I try to convey is that once we pull, we observe like the particular phenomenon, a legal phenomenon, right? We have to think about it. So that's the difference between knowledge and thinking. Think about it logically. What does it mean, like theoretically, right? So at a certain level, maybe not a 30,000 feet level, but at a certain level, the question is going to become universal. For example, the relationship between law and development. For example, the nature of property rights. Those are just universal questions across different jurisdictions. All the questions like why do people obey the law? That's universal. And by asking such like more general or more fundamental questions, you actually make countries comparable because each country is more like an experiment of this specific question, right? They come out with different results. So that's the first reply to your question. The second one, I do want to, because it reminds me, I do want to talk a bit more about comparative research. There are two approaches of comparative law, going back to probably one of my first slides. The first one is what I mentioned like at the end of the presentation, right? Like a comparative constitutional law. So in your book or in your chapter, you lay out all the different countries, right? For example, all the different socialist countries, what their constitution has said about, or all the constitutional amendments in the past decade across the world. It's like a direct comparison. So in this approach, I do think there is a challenge, what you have mentioned, like a big challenge, right? Because for example, a same constitution says about the same thing, like has adopted a same concept. But for the scholar from that country, he or she actually knows that that concept as adopted in this constitution is very much different from the same concept, like a same word, right, in another country. So I think that's something, frankly speaking, the comparative studies of black letter laws, that's, I think, what the comparative constitutional law, where it is at this stage. I don't think a comparison of black letter laws can really conquer this challenge, right? So that's the first approach of comparative law. So to really overcome this challenge, that's the second approach. It's basically a trade-off, as I have said, a trade-off between depth and width. That's to say, for example, the country-specific studies, right? Such as John Haley's study of Japanese law, the spirit of Japanese law. It does not do any systematic comparison between Japanese law and American law. But it touched upon the nature of society, like the communitarian orientation, right? Why does he say that? That's actually in light of the individualistic culture in America, right? And by doing that, he presents at least two categories of society. One is communitarian, the other is individualistic. In that sense, it is comparative without a systematic comparison, right? And it is not less good than the first approach. It has the depth, and actually I would say it's a comparison in the deeper sense. And it's much more difficult, frankly speaking, to do that. That's also approach I have been doing most of the time, but I don't think there is a like good or bad between the two approaches. If you are a scholar, I mean, most of you are in the future, you should try both approaches to see which one like suits you the best. Thank you.
Thank you so much for the response. It was, yeah, it answered a lot of questions. So we still have 5 minutes for for Q&A. So we have a question from the chat box from Yi Tang. So he or she asks, when doing comparative study, we may always be asked to justify the selection of the comparators. Example, why do you choose to compare China with the US instead of the United Kingdom? Do you find the difficulty to justify the selection of the object of comparison?
Sure, that's a common question, but also a very important question. Frankly speaking, I think it's very hard to answer it in an abstract way. That always depends on, again, your research question and also your theoretical framework. I don't think you have to answer that very clearly at the beginning of your research. But I guess a common answer is that eventually these countries present, for example, different answers to your question, right? So there are different kinds of comparison, right? One kind of comparison is that, oh, these two countries are different in every aspect, but actually they converge on a same result. For example, that's the only comparative piece I did in a co-authored work called exclusionary megacities, right? So cities in China and the US are governed fundamentally different, right? One is decentralized, the other is centralized, right? And one is driven by, by politics, the other is very much driven by business, etc. Then why both cities have become exclusionary, increasingly exclusionary, right? The housing prices are so unaffordable in New York, but also in Shanghai. So our approach of comparison in this project is to say two cities or two jurisdictions are different in almost every aspect, but they converge on one thing. So that's one method. The other method is that two jurisdictions are almost the same on everything, but they differ, right, on one significant thing. That is like the natural experiment, right? It's like all are the same, but with only one difference. So what drives that difference? That's like another way of comparison. And there are many other ways of comparison, but those are just two examples, right? One is to find the similarity among differences. The other is to find difference among similarities. But that's, I guess, a short answer to a very important question. And thank you. Yeah.
All right, thanks. So we have a question from Alan Ko, and we will unmute you and you can open up your camera and you can speak out.
So anyway, I've decided to type down my question instead because I think it's a bit easier to follow. It's kind of long. Anyway, I just want to say hi, Shitong. It's really been a long time. I'm very glad to see you doing well.
Yeah. Really good to see you here. Yeah.
Thank you. I'll let you read. Yeah.
Sure, I can. Determine the fundamental legal aspect that comparative law reveals. To what extent is this perspective or the retrospective analysis? From the perspective of the author who is setting out to make a contribution to the broad law community. By retrospect, I refer to law scholars looking at my work and explaining how it is relevant to the broader law community from their point of view. It seems that in explaining how Haley Upham have made a contribution to law more broadly, they are taking a retrospective approach. To what extent do you think that the prospective approach matters? Okay, which is what the author themselves intended, versus a retrospective approach, which depends on how other legal scholars interpret the work and maybe involves some luck. Oh, Alan, that's just a fascinating question. That's I can share with you. You probably know about this. Share with you my experience, but you probably have your own takeaway too. Right? We just I think that's a conundrum. I don't know what this is. What you indicated as a comparative legal scholar. When you do something, well, for example, I intended to be theoretically innovative, but maybe what other scholars have seen in my research is really just a country-specific study, right? I think that's kind of what you indicated. I think that's always a challenge. That's always a challenge. But I have, I would say, at least two responses. the first one is that even just to make your work readable, in a sense by those like leading scholars, you have to engage with the theories, right? So maybe for the leading theorists, they take your work just as another case study from China, from Singapore to their theories. But that's also because you have done a theoretical work. Otherwise, your work would be, how to say, illegible to even these scholars. So that's the first response. But the second response, I do think, this is at least what I'm trying to do, is that you have to tell them something new. So it's not just, oh, you confirm their understandings, right? Is that what's your own theory? Is their theory is going to be good enough to to be paid attention to? I guess it's probably like an author's self-bias, at least from the commentators on my book. I think they focus on actually the theoretical contributions. So that makes me happy. But of course, that's not always the case. But anyway, I guess the takeaway is you have to engage with a dialogue, a conversation. It cannot be just the Chinese is talking in Chinese. Then like what's like what is in the practical sense or in the theoretical sense? That's just not interesting, right? And last word, because this is a question I thought about a lot. I mean, there are good theories and better theories. I'm not saying that we have to compete for the attention of some individual scholars. I don't think, at least that's not my pursuit. I do think those good theories, even though they are developed from a specific country, and most of the times, frankly speaking, from the United States, I do think the good theories are insightful and universal. So in other words, our American law professors, for people who are doing their studies or did their study in American law schools, they are also doing comparative law. They are doing comparative American law. But I think I do learn from them I do learn from them like how they thinking about like doing legal studies, right? How they think about law, how they think about the interactions between law and society. So in that sense, it's not a competition for their individual attention, like a personal level. It's really to say that I think these people have done great research. I want to improve myself to say how I could do greater research with the legal phenomena or the institutions I'm familiar with. I guess that's just my my personal feelings. And thanks so much, Alan, for the questions. Appreciate it.
Thank you so much, Mr. Adam Toad. And then we have our last question from Ming Sung Kim. You can introduce yourself and then you can ask your question. Thank you.
Yeah, thank you so much. Most of all, thanks to Simon, I can participate in the meeting for the conference, the Zoom meeting, and I will work in the Hong Kong University, the Medical Ethics and Law Center from May 1. So, and my plan I'm interested most of all, you explained about the code evolution, the social norm and the law. In my perspective, I mean that I will consider how co-evolution, medical ethics and law interdisciplinary the research. So if you're okay, could you please explain a little bit more how could you design the co-evolution between the social norm and the law? Because that is my big challenges whenever I research some parts, and I consider the integrity, the perspective, but in my level, so a little bit the top challenge to understand the co-evolution between the law and the other value and the principles.
Thanks so much, Min Sung, and very great to see people from Hong Kong. So I'll give you, I don't know much about law and medical science, but I'll give you one example. This is what I got from my book. The theory itself is a bit complicated, but eventually, if we have to to present like a simple takeaway, right? The puzzle is that, for example, in my study, right, you have law, you have social norms, or you have state, you have market, you have community, right? So each follow different rules, right? The question I'm asking is that why a change in one system would cause change in another system, right? You can, for example, I don't know, like for example, in law and medicine, I'm sure there are like a practice or social norms of doctors, right? But there are also like legal regulations. Why do the two systems, the regulations and the norms of doctors, why like one change, like a change in one area would cause change in another? A conventional answer is that, oh, that's because of like enforcement, right? The law enforcement would change people's behaviors. But I think that's just, that's probably right in some cases, but I think that's probably a partial and a narrow view one. I go actually eventually to go this is from the biological science, right? And sociology is the intersection. Basically to say that these are different areas, but these different areas, they share the same actors. What does it mean? A doctor, right? A doctor, let me say, okay, I'll give you my example. Like in my case, a village head in Shenzhen, right? He is part of the official system. So he's like the lowest, like the lowest level of government official. So he's in this governmental regulation system. But that's one system. That's one identity he has. But another identity he has, he's also a representative of his community, like the senior elder, right, in his community. And the third identity is that he's also the CEO of the village co-op. So that connects state, community, and market. So in each zone or in each forum, different rules follow, and different calculations actually this village head would have. But eventually, one change in one area is going to have an impact on his calculations in other areas, but not exactly as the law enforcement literature would indicate, right? The process is a bit more complicated. So this co-evolution focuses on the different identities and simultaneous actions taken by the same actors, right? So again, just going back to our daily life, a person, I'm a professor, but also I'm a father, I'm also a son, right? So different areas. I'm sure that logic is probably also applicable to the area of law and medicine. So the importance is to focus on actors and also to focus on like how one calculation in one area could be converted to other areas. So that's what makes co-evolution possible. Of course, that's just one part of this theory, a simple takeaway. But thank you.
So, yeah, so just a little bit specifically, so you said the actor that converted like some aspect to another aspect, that we need to study how these changes can influence the other area, and which design is the most effectiveness to where converted the other area. It is right?
Yeah, I think that, yeah, that's important. Yeah, so that's actually is a departure from the law enforcement literature, right? Law enforcement basically, okay, we increase the law enforcement, then everything is going to change. No, you actually have to understand if the calculation in the legal zone changed, how could that going to impact, for example, the norms of the community, right? What you have to actually focus on that, not just simply like enforcement, right? So very nice. Yeah.
Oh, thank you so much. Very helpful to understand how the co-evaluation with the law and the other area. Thank you so much.
Thank you, Vincent, for your question, and thank you so much, Shitong Qiao, for the response. So we have reached the end of our session, actually 9 minutes after 10. And thank you so much, Professor Shitong Qiao, for joining us and for lingering around.
Thanks, Simon, for the invitation, organization, and thanks everybody here for being here in the evening or in the morning in Indiana. I appreciate it, and please feel free to get in touch if you have any questions. I'm happy to talk. So yeah, thank you. Thank you.
Thank you so much. So thank you everyone who attended. Our next event will be held on April 8th. We'll invite Professor Francisca Bignami to talk about the advantages of comparative law's functional method, and I hope to see you there. So thank you very much.
Thank
See you
you.
in our next event. Bye.
Thank you. Bye. Thanks.